On Elizabeth Gorsay.
Gorsay with a V?
Gorse or Gorsay? Gorse, yeah, over
With a V?
V. With a V as in Victor. Gorse. I'm saying.
Got it.
I'd like to say that.
Your appearance.
Thank you. Please state your full name for the record.
Elizabeth Vorse.
Thank you.
Josh Hadley, on behalf with my client, Miss Elizabeth Gorse. Today's the date and time set for sentencing. We would have a chance to BSI. We have no factual relations corrections to make. Practically speaking, we have one question.
Good.
And it is about condition number 6,
Gotcha.
the testing for, or the fingerprint.
Right.
I believe MSP was the arresting.
Yes.
Hell yeah. Are we talking one of the outposts, or is she able to?
We've got all that. What happened to that paperwork? Is it in here somewhere?
Yep, it's in file.
Oh, it's right here. Yeah, so she's got to go to MSP South and she only do it Thursday mornings.
If that one's in Taylor, okay.
Yeah.
She's a resident of Toledo. Maybe if we could get, does it say 14 days to get that one?
We
done?
give her till February 5th, so she's got 2 Thursdays. I mean, she can even try on your way home today. Maybe they'll take you this afternoon. I don't know.
No, it's better than a drive up.
Might as well try.
That we're just kind of trying to hope that it wouldn't happen.
So we'll give you the paper you need when you walk in. Okay.
Okay. Otherwise, Your Honor, no issues. Awesome. So as I have, yeah, right here. That's what you're looking for. If you Google folks 22, it'll take. Okay, Your Honor.
Post 25, I think. Post 22 is somewhere else. I think. I know it says post 22 is.
It's in Taylor. Just Google Michigan State Police, Taylor, Michigan.
There's the one in Oak Park and the one in Taylor. I think those are the only outposts or anywhere
Yep.
close here anymore that are like substation or that aren't substations. Otherwise, Your Honor, all of the conditions, recommendations, we would ask the court to adopt for.
Ma'am, anything you want to add? All right.
Well, let me, I say that.
He can't help himself.
You can celebrate a little bit. So how many days are we looking at?
70.
All right.
For you.
So, yeah.
How? What are you doing?
I'm a caregiver, actually, for seniors.
So focus what was I doing with my time and some of the issues into other people's needs. I think it'd be the cleanest way to kind of what we've talked about this summer.
Okay.
So, sorry, I said I got nothing to say. I'm like, no, wait, you've been so.
I knew that was a lie.
But otherwise, I'd like to boast that to the court that she is walking the walk.
Okay. All right. So first I'm going to sentence you, then I'm going to appreciate you. So the sentencing is I'm going to adopt in full the recommendations of the probation department. I'm going to put you on for 12 months, 40 hours community service. Everything that was in that is recommendations are now court ordered. Fines and costs $1,300. Can you pay that today? All right.
Yeah.
Yep. They'll tell you what your options are downstairs. All right. So here's I'm going to preach. I'm getting really preachy today. I apologize to all of you. But you're court ordered, so you're stuck with it. Your blood alcohol level, I think, is the highest I've ever seen. I know it's the highest I've seen in a long, long time because I don't remember a higher one. At a 0.35, if you would have been in a car accident and they took you to the hospital and your blood level came in at 0.35, they would have admitted you. Because at 0.35 is when your involuntary muscle groups can just say, screw it, we're not working anymore. You know what those muscles are? Your heart and lung. So you're literally at 0.35 medically is when you're in danger of your heart and your lungs saying, screw it, we're out. You were there, you were past there, you were 5 times the legal limit. Now I'm telling you all that not to make you feel bad. That's not, I'm not doing that. I'm telling you that because I want you to have the right mindset as you go into this probation. I put people on probation not as punishment, but because I determined, and I can do that. I've determined there's some behavior that needs to change. So one of the things we've ordered for you is substance abuse evaluation and or treatment. I don't want you to walk into that with the idea, Oakley's making me do this, I'm just going to do it and get it over with. I want you to walk into that with the idea with, I'm here, what can it teach me about me?
That's why I'm making the change now.
And that was very, very tail wagging when he said you got 78 days of sobriety. Okay, that's a pretty good start. But I want you to hear my heart. And I noticed that you told her that you thought you were a social drinker. You've got an alcohol problem because alcohol has caused you huge problems. And you and I could spend the next hour and talk about all the damage that's happened in your life, and alcohol was at the bottom of it, right? Okay, that's an alcohol problem, right? Okay. So I hope, hopefully that flips a switch in your head. If it needed to be switched, if it needed to be flipped, it flips it, and just go into this with the idea, I'm doing it to stay out of trouble, right? I'm going to do what Oakley told me because I don't want Oakley to put me in jail.
Save my life.
Then I'm done talking. Have a good day.
You know what, Your Honor, we appreciate that, and thank
Yes, we
you.
do. Thank you.
Of clients, I know that this is being received,
Good. Good. Appreciate it. Good luck to you. What's next?
All right.
One of those courtroom moments that stays with you long after the hearing ends, not because of shouting, not because of jail time, but because of how close everything came to irreversible tragedy. This case centered on a Dewey sentencing involving one of the highest blood alcohol levels the judge had seen in years. And from the moment that number was spoken out loud, the tone of the courtroom changed. A BAC of 0.35 is not just illegal, it's not just dangerous, it's medical, emergency territory. The judge made that point unmistakably clear. At that level, the body is no longer simply impaired, it's failing. Heart function, lung function, involuntary systems that keep a person alive can simply shut down. The judge wasn't exaggerating. He wasn't being dramatic. He was explaining reality, and that reality was sobering for everyone in the room. What made this case different was not just how bad things could have gone, but how close they already were. The defendant wasn't standing before the court after a near miss. She was standing there after surviving something that routinely kills people. The judge didn't use that fact to shame her. He didn't weaponize it. Instead, he reframed the entire sentencing around one central idea. This wasn't about punishment. It was about survival. The court acknowledged the progress already made. Days of sobriety, engagement with treatment, a visible effort to change. But the judge made it clear that progress doesn't erase risk. It doesn't undo the past, and it doesn't mean the danger wasn't real. One of the most powerful moments came when the judge challenged the defendant's own description of her drinking. When she described herself as a social drinker, the judge stopped her, not harshly, but firmly. Alcohol had already caused significant harm. Alcohol had already brought her into the criminal justice system. Alcohol had already placed her life, and potentially others' lives, in immediate danger. At that point, labels no longer matter. This wasn't about how often she drank. It was about what happened when she did. And that distinction is critical, not just in court, but in life. The judge explained that probation in this case was not meant as punishment. It was an intervention, a structured pause designed to force reflection, accountability, and learning. The court wasn't saying you're a bad person. It was saying this behavior cannot continue. That's an important difference, and one the judge returned to repeatedly. Substance abuse treatment wasn't ordered as a checkbox. It wasn't a hoop to jump through. The judge emphasized mindset. He wanted the defendant to walk into treatment not thinking, the court is making me do this, but instead asking, what can I learn about myself? That shift matters because people who approach treatment as punishment rarely change. People who approach it as understanding sometimes do. The judge also made something else clear. The court's patience has boundaries. Sobriety milestones were acknowledged but not celebrated prematurely. The judge reminded her that early success is fragile, that confidence too soon can become complacent. And complacency in cases like this can be deadly. This wasn't a feel-good moment. It was a warning delivered with care. The judge didn't sugarcoat the stakes. He described exactly what could have happened: a crash, a hospital admission, a funeral. He wasn't trying to scare her. He was grounding her in truth. And then he did something that separates experienced judges from performative ones. He stepped back. He made the expectations clear. He set the conditions. And then he stopped talking. Because at a certain point, responsibility cannot be explained any further. It has to be accepted. This case highlights the justice system at its most preventative. The goal wasn't revenge. It wasn't public humiliation. It was to interrupt a trajectory that could easily have ended in loss of life. The defendant walked out of that courtroom with strict conditions, real consequences, and a clear understanding that this was likely the last opportunity to correct without catastrophic fallout. And that's what makes Case 5 so powerful. Not what happened, but what almost did. This was a moment of grace, but not grace without structure. A moment of restraint, but not weakness. The court recognized the seriousness of the danger and responded accordingly. Because sometimes the most meaningful sentence isn't the one that punishes the past, it's the one that protects the future. And the judge made one final thing clear. Probation is not the end of this story, it's the test. What happens next will determine whether this hearing is remembered as a turning point or a missed warning. The system did its part. The risk was explained. The line was drawn. From here on out, the responsibility belongs entirely to the defendant. And in cases like this, the margin for error is gone.